Good evening and welcome to another episode of Law and Order, a program on ChannelEye Rupavahini where we discuss the legal matters of various subjects and various titles. And today joining me for our discussion on a very important topic about labour law. What is labour law? How does it govern in Sri Lanka? Who comes under the Act of Labour? Well, to discuss all that, I have with me attorney at law, a senior attorney at law who's been in the profession for over 4 decades, Mr. Tirina Panditharatna, joining me today. Good evening to you.
Good evening to you.
Yeah. Well, it's definitely, if you talk about labour law, it's a very vast area that you cover. But let's start off from the roots itself, Mr. Tirina, on who comes under. It's like, what is employment? If you can explain to our viewers what really employment is.
Yeah, employment is when a person, you need money, so you have to sell what you have. That means your talent or any other ability or skill, you sell it, in short. And employer pays, one who buys my services pay for me. So there are two parties. One is person who is giving his ability and talent or the labor to the other person pays for it, consideration is passed. So that's called salary. So that is how the workman earn money. There the connection between the two is called the contract of employment.
So does a person who sells goods also come into this?
No.
No, it's just providing your services.
Services, individual,
personal services. So there's nothing to connected with if you sell anything. Just because you become a salesman, that doesn't mean that you're selling your service. You're selling your goods.
No. That is not
right.
Your personal ability or physical ability or your talent or your knowledge. You sell it, you give away, and for which other party pays for it.
Right. So, are there any types of this employment?
Yeah, there are a lot of now. For instance, the contract of employment. I mean, between the two parties, there should be two parties. Especially, we call it as employee and employer. Those are the two parties involved in that. And beside that, there is another thing that we have to think about, as you question from me about a seller selling things. I would like to say that there is something called independent contract also. The for service and of service, contract of service. There is one word called contract of service, another word called contract for service. Contract of employment is you sell your ability, knowledge or anything what you have. Contract for service is an independent contract, where a person who try to take over to construct a building will say, I am the contractor and I engage my workers to construct the building. So, I will not become an employee, I am an independent contractor. So, most of the labor laws won't apply to independent contractors. But the people who work under the independent contractor, there is a contract.
For example, you say, I am the contracted person by somebody to build something. I am the person who is liable, is it?
Yes,
not
that's
the
right.
person, not the people working with me.
That's right, you are correct. Yes,
right.
That's that.
Yeah.
That's in that case you call contract for service.
Contract for service. Yeah, so that's, I think, a very interesting thing. Now, you talked about the employer and the employee. How does the right happen for this? Like, say, how does the entire thing work around?
Yeah, you mean to say how it comes to existence?
Existence.
Yeah. Now, actually, in our in Sri Lanka labor law, there is no need or there is no law to say the contract must be in writing. It can be in writing or it can be verbally also, and also by behavior also. The contract of employment exists or come to effect with all these ways. I mean, maybe in writing or verbally or by behavior.
So, can you explain a little bit, like when you say behavior, now that's something that we would really like to know. How does a contract come into play when it's based on behavior?
Now, for instance, if I am leaving my country, you will say you are the driver, I hand over my car with the key and I go abroad. So, it is in short, I say that you have to look after my car, you drive my car, you keep my car in good condition.
Yeah.
That means I didn't say anything to you, but it is intention is that you have to keep my car in good condition, you have to drive, maintain the car. So, that is your a driver or a person who is looking after my property.
So, that is how behavior contract.
Contract.
So, verbal contracts, so that is something obviously must be having a lot of issues in Sri Lanka.
Yes.
But how strong can a verbal contract be?
Yeah. Now, for instance, verbal contract means I can just say, come, you work in my estate. So, he comes and works. At the end of the day, I make some payment. So, that is verbal. But only thing, the most important still, that verbal contract is also legally can be enforced. Even though it is by word or mouth, it can be enforced. It all depends, because now in the for instance, if there is a problem like that, if the employee was sacked at once, so he has to take some relief, seek relief from some authority. So, at their labor courts, that is called the labor courts, they listen to both parties. So, even though it is verbally or orally it is done, they listen, just an equitable order will be given, what really happened, whether it is in black and white or not is immaterial. So, they want to find out, the judge who is inquiring into the matter will listen to both parties, and he will decide the type of contract that we had.
So, in terms of verbal contract, so even if you have a verbal contract, the person who was employed can be, if he is, for example, terminated immediately or without any notice, can take this matter up in a certain place to defend himself.
Yeah, it all depends, because there are various type of employment. For instance, you can be a permanent employee. You give a letter of appointment to say you will be employed for this particular designation with this particular salary, and your retiring age is 55 or 60, whatever it is. So, that is a kind of permanent employment. Now, if during tourist season, for example, only for during the season I engage a person, that is called seasonal employment. Or else if somebody employee dies, so to fill the vacancy I get a person to work temporarily till I recruit a permanent person. So, that is called temporary employment. And also there are instances, especially in the trade of tourism. Now, the hotels, as you know, there is a season in tourist season. So, it lasts for 3 months or 4 months. So, I say that you will be recruited as the room boy from this date to this date, that is for 3 months, or that is the exact, that is called the fixed term contract. At the end of the period, automatically contract of employment comes to an end. And also there is a casual nature also, casual employment. The casual in the sense, now for instance, we will say that all days you get dirt and the place get dirty. So, I engage a person to clean up the place. So, when the necessity arises, I engage only to fulfill that necessity. That is called casual, that on and off.
So, it can, so basically employment can vary from various, it can be permanent, it can be casual, it can be temporary, it can be just
fixed term.
Fixed term. So, okay, let us come to the point where when if a contract ends suddenly, or it is terminated, or the contract is breached, how does the employee act on this, and how does the employer act on this? And is that when the whole word labor law comes in?
Now, for instance, now as you quite correctly mentioned, question me, what is the relief I can get? How I am going to get the relief? From where I get the relief? There is a law. Now, for instance, if they are permanent employees, there is a act called Termination of Employment Act, but that is controlled by the Commissioner of Labour. That is called on non-disciplinary termination. For disciplinary termination and another type of termination, you have to go to labour courts in the sense labour tribunal. There is the special act called the Industrial Dispute Act. Under section 31B, you can make an application to the labour tribunal, saying that I was working and I was terminated on such and such a day. Then that matter goes to the labour tribunal, and the respondent is noticed. Respondent in the sense the employer is noticed. He will be asked to file an answer. Once after filing the answer by the employer, employee again will be asked to file a reply to the answer. Then thereafter it will be called for inquiry. That is called trial also. So, they learn a judge of the court, listen to both parties and deliver final judgment. But whereas there is a difference between a normal court and labour court, the labour tribunal. That is normal courts, they are 100% had to adhere to the law, strict law, but in labour tribunals, strict law is not there, because the learned president or the judge of the labour tribunal has to deliver an order which is just and equitable. So, there is a difference, but in the other courts they do not have that particular power, but labour tribunals they have.
Well, now that is something interesting, because now normally if somebody, for example, I am terminated from work suddenly without any proper reason given, then where do I start? Now, if it is a normal thing, first thing I would go is I would either go to the Grama Sevaka, or I would go to the police station to lodge a complaint, and then you take it from there, and both parties are summoned to the police station.
Yeah.
So, in terms of this, obviously you do not need to go to that extent.
No, not necessarily. Actually, law does not say that you have to go and lodge a complaint at the police station. You need not go to Grama Sevaka or any other person, but usually what happens is when a labourer, ordinary person, get his services terminated, he does not know where to go. So, he used to go to the police to complain it. Then the police may record his statement, but police is helpless. Police can't give orders, directions to the employer.
Putting it very short, police can't police the matter.
That is right, yes, correct. But the police record the statement.
Yeah.
And also the person who get terminated can go to the Commissioner of Labour. In every area there is a district labour office. They can go to that place and make a complaint. But the labour department also handles, try to bring both parties together and try to settle the matter. But if they fail, ultimately they have to go to the labour tribunal.
So, we at the start talked about employee. So, now we are talking about labourer. Who really comes under this category of labourer? To what extent is a person being identified as a labourer?
Yeah, labour is a very vast term.
Yeah.
There are two definitions, interpretations. Who is called as the labourer? Labourer includes all people who are employed. Even an executive comes as
that is what I wanted. So, if I am an executive in a good environmental office, I still become a labourer.
Labourer, yeah, that is right. You call it as a labourer or labour.
Yeah. Because in Sri Lanka, what you say, when you say the word labourer, or if you come to the singular term saying kamkaru, people feel that there are people who are not like who sitting in office and working, but then everybody, according to you, now comes under this category of labour.
Labour, that is right, yes. Because in the act it says labour, because actually it is called the employee, sevakaya. So, it covers, word sevakaya or employee covers all sorts of designations, not one designation as a mere labourer, hard working labourer. Not only that, even the executive, if he gets a salary or employed, he becomes a labourer under the labour law.
So, I think that is very interesting. So, let us elaborate a little bit more about this labour law, because it is getting very interesting now, because I think our viewers will be now thinking, okay, everybody is a labor if you really correct it. It's not a person who would work like with very small wages, but anybody even getting a higher wage can be a laborer. So if you can,
yeah, it's actually it's not a laborer.
yeah,
Under the labor,
yeah,
word labor, or the employee,
yeah,
there is a definition. Even definition now, if I employ you, directly you are an employee of mine, but I can ask you to get someone employed to do my work. So that means he was called to work on my, you will call him on my behalf. Then again there is an employment contract where he works through you, you get the worker to work on my advice. So he will become an employee of mine. Understood?
Yeah.
Yeah, that's how it, because there are a lot of interpretations.
yeah. I think that very clearly defines what really is. So how does the next process go? You told that how you can then you either go to the labor tribunal or whatever. Then how does all this happen? But before that, does Sri Lanka and all the other countries, when it comes to labor law, is it the same law that's been practiced around the world?
It's actually labor laws. India is very similar to our pattern, our type of employment termination and all those. But in English countries, little bit different, but the English law applies. We are based on mostly the Roman Dutch law, which devolved into the industrial law and all those things. And also, when you go to the labor courts, I mean to say the labor tribunal, there is another thing that I have to mention. Not only the labor tribunal, you can go to the Commission of Labor, complain, and under the Industrial Dispute Act, section 4, for that particular dispute between the employee and employee can be referred to arbitration. That is also kind of settlement. Arbitration also under the Industrial Dispute Act, Commissioner, there is the special branch in the labor department, arbitrators are appointed, usually retired judges or lawyers, senior lawyers. They will judge the issue, they will listen to the issue. So likewise, there is an industrial tribunal like court, and labor court is a normal one, everyone is going there, even for a simple thing. If the services are terminated, they go.
So this labor tribunal or the labor court that hears these cases, as you mentioned, so does that only these courts, is it separated from the other courts, or is it just within the court premises?
Sometimes now, for instance, in Galle is a separate place. In Kalutara, for instance, in the same judicial, I mean the complex, you have the courts there. So likewise, it depends on the availability of space.
So, so this labor tribunal or the labor court, they only take down labor cases. For example, if you take the High Court, the magistrate, you take various types of cases. But in terms of the labor tribunal, it's only the labor matters.
Labor matters here, pertaining to anything pertaining to employment. It may be termination or retirement or vacation of employment or dismissal, whatever the cause. When the contract of employment comes to an end, anyway, it may be a constructive termination, it may be direct termination or dismissal from employment, or by force you send a person under resignation or leaving. So, anything which terminates the employment comes under the labor.
Now, can this go vice versa? Now, for example, I am the person employed and I suddenly vacate post. I just don't come for work. I just leave the place and I don't want to attend. Then can the employee file action, and does it also come into the labor law?
Yeah, that's right. Good question, because sometimes worker himself won't report for work. He is at home without coming for work. So the employer has to take somebody to do his work, and employer usually it has to be must send a notice to him asking him to come for work. Give some, because there might be reasons he may fall ill or sick, then because of that he can't come. Likewise, with any other difficulties. So, but it is the duty of the employee to inform the employer why he is not coming for work. If he fails to inform the employer, employer can treat him as a vacated employee. Because the employer has to issue notices or inform him, asking him to come for work. If he fails to come, he can treat him as a employee who vacated employment. But there again, there are two things that comes to play, most important things. One is physical absence from employment. Second, then mental element, that is, he must have, the worker must say that I am not going to work anymore. That is the mental, he has an intention not to work hereafter. So, that has to be proved, not only mere absence. So, the two elements are that, the mental element and physical element. So, only those two, the two things comes to part, then it will be treated as vacation of employment.
So you mean to say that even the employee has the right to challenge the labor, if you say a laborer or the employee,
Yeah.
if he terminates the contract without notifying the employee?
Yeah, actually, that can, it depends on the time period of absence.
Right.
Absence. Now, for you get yourself absent for a day or two, you can't treat him as a vacated employee, because it depends on the circumstances, also the duration. After asking him to come, asking him to report for work, he still fails without giving any reason or without any information passed to the employer, he keeps away. Then employer issues a final notice, here if you on now before such and such a day, if you fail to come, I will treat you as a person who has vacated employment, and I will recruit someone else in your place. So, that means you are giving the opportunity or chance to the employee to come for work. If he is not deducing any reason, that means he has an intention to keep off. That will be proved. Then you can treat him as a vacation.
So, it is like somebody asking you, like if you are absent, like to send in a show cause letter or something like that, why I am not being. So, if that does not happen, then the employee has the power to start working on it.
That is right, to treat him as a employee who vacated employment.
I think this has been very interesting, finding out what this labour law, especially starting from the employer. But I think unfortunately time is caught up with us on today's episode. So hopefully we will be joining you on our next episode with Mr. Thilina itself to discuss on how the labour law applies in Sri Lanka, to what extent can you take it, what are the actions that you can take if you are not a satisfied person by the verdict that has been given by the Labour Tribunal. Well, to discuss all that, we will meet you very soon. So till then, it's goodbye for now.